ready. Okay, good morning and welcome to the State Ethics Commission. And today is December 18th, 2024. The time is now 9 o'clock. May we have a roll call and make sure everybody is alone?
Sure, starting with Vice Chair Tobias.
Present and alone.
Commissioner Thielen.
Present and alone.
Recognizing that Commissioner Becker, Commissioner Hong, Chair, myself, and Miles are in the conference room, public hearing room. I'm going to turn to staff. Staff, you do not have to indicate that you're alone. That requirement's only for commissioners for purposes of the Sunshine Agenda. But just to introduce yourself, starting with Benita.
Benita Chang, Compliance Director.
E.
Key Campbell, Enforcement Director.
Patrick.
Patrick, IT Support.
Jennifer.
Good morning. I'm Jennifer Yamanuha, Staff Attorney.
Barbara.
Barbara Gash, Investigatory Analyst.
Jody.
Good morning. Jody Yee, Staff Attorney.
And if members of the public wish to introduce themselves.
Guess not.
Okay. I'm recognizing we have Dana Kasu, Candace Park, our Deputy Attorney General, and Patty Epler also joining us.
Okay, thank you very much, Robert. First on our agenda, Director's Report, Education and Training Report.
I can turn that over to Benita.
Good morning, Commissioners. For December, we were really busy. We conducted 2 lobbying training sessions on December 5th and 6th. The first one was a substantive law, and the second one was the optional one on the lobbying e-filing process, and those are well attended. Our 2025 schedule of live trainings is already posted on our website, and we have several that are already lined up after the new year for again, lobbyists, and then also general ethics. Because this is a new legislative biennium, we have a lot of people that are coming online to register and take the trainings. In terms of disclosures, similarly, because of the biennium, we are seeing a lot of new registrations come in and increased call volume. We generally range about 500 plus registered lobbyists and about 450 client organizations. So we anticipate seeing those levels again this year, maybe more. In addition to handling disclosures for the lobbying side, we've developed we're working on a new flyer to inform lobbyists and their clients about the new lobbying bill reporting requirements, which will take effect January 1. To date, we've updated and posted all of our guides regarding financial, gifts, and lobbying disclosures, so those are already up. And in January, we'll start receiving disclosures from legislators, which are due January 31st. And as part of the standard courtesy reminders, we've updated our filing tips to explain the new reporting requirements that will apply just to legislators on lobbying affiliations. Thank you.
One comment, actually, when we mentioned at our last COGO conference, our training program, everybody was very impressed by the fact that we had 85% of, the people taking a mandatory class, which says a mandatory class. Well, if you don't pass, you get fired, we told them. but thank you very much. I was a little remiss. Item number 1 is a consideration and approval of minutes of November 20th. Any corrections? If not, I'll entertain a motion that we approve the minutes.
Move approval.
Moved by Commissioner Hong, seconded by Commissioner Thielen. All those in favor? Roll call, I believe.
Starting with Vice Chair Tobias.
Aye.
Commissioner Thielen.
Aye.
Commissioner Becker.
Aye.
Commissioner Hong.
Aye.
Chair.
And chair votes aye, no objections, the motion's carried. Next, under Director's Report number 2, Guidance and Assignment Statistics.
If I could turn that over to Keith.
Sure. So in the month of November, we received 37 new complaints. We closed 32 complaints. Additionally, on the year, we have received 395 complaints and have closed 391. So we continue to close the complaints as they come in pretty much and then work on the pending cases.
By the number of complaints that we decline or denied, I guess, is it because now they're more aware of maybe there's a violation, so they'll file it anyway, but yet it's not really a cause of action?
We get a large number of complaints that are essentially denied for lack of jurisdiction. And, there's a bunch that are more substantive that we look into where we just cannot find evidence of a violation. But you're correct. A decent number of those are, complaints where they don't state of cause of action. So in those matters, we refer them to the appropriate agency, whether or not it's federal, state, or county.
So is it a result of our great training that everybody's getting on the bandwagon and?
Yeah. I think that definitely plays a role. And then, we refer people as appropriate, even when there's no jurisdiction. So, I think the system overall is, working to help people to provide a solution.
Chair, just if I can add a bit of color, I think there are typically two systems to accept complaints. There are some jurisdictions that have a very restrictive system where people will have to file an affidavit or something else alleging the complaint, or even filing the complaint themselves and prosecuting it. And those, the statistical likelihood of getting a valid complaint is much higher, but they also get far less in the way of complaints. Our system has been a much more open system where we essentially will take a complaint from anyone. And frequently there are folks who are frustrated with a difficult factual legal situation, and they'll take a insert complaint to everyone approach. I think our staff has done a really good job of trying to be empathetic and try to redirect, in a, as reasonable a way as we can to the right appropriate agency. So, it is a big part of our job to kind of weed through complaints that aren't really our kuleana specifically, but I think the wide open funnel, I think, is generally speaking a good thing, because it allows us to help those folks find an appropriate place when we can. But secondly, it increases the chance that we are going to get some valid complaints coming through that we can then address. So we are looking at next year taking some steps to try to build in some automatic referrals, like as people are filling out the complaint, to try to get them more quickly to where they need to go. But I think we're going to still continue to have a fairly open system to allow people to file complaints with us.
Okay, thank you. So rather than wait to the end of the director's report, are there any questions from the commissioners in regards to training or statistics? How about the public? Any questions in regards to training and statistics? Okay, item number 3, miscellaneous.
Thank you, Chair. So just briefly, as you recall, in the beginning of 2024, we adopted some goals, and I'm just flagging that in January, our intent is to come back with a report on how we've done on those goals, as well as proposing some 2025 goals for us to tackle. The idea is to try to help staff focus on the things that, in addition to sort of the normal course of business, things that we want to work on in specific. If the commissioners have anything that they really identify or perceive, I'd encourage you to reach out now with the idea that we can have an open discussion in 2025, that the idea is we're going to give you a straw proposal of things to consider for the year. And, we can always continue the discussion as need be. Finally, also the intent in January is to give you a draft annual report, which is required for us to do each year. And our hope is to be able to give you some of these statistics that we're talking about with more, in breadth, what's the annual look at these things. In that note, because we have adopted a new case management filing system, we hope to be able to provide more data on a going forward basis. It probably will not be ready for this report, but on a going forward basis, we might be able to start showing more information, like specifically when these complaints come in, which ones of these were rejected because of lack of jurisdiction, trying to get more accurate statistics on that for public overview. Finally, we did also purchase a new video system that we're going to start using for our conference meetings. Probably not necessarily needed for our commission meetings. Probably not specifically needed just for commission meetings, but also anticipating when we have contested case hearings where we may need more microphones, more video systems. We were able to get a pretty good deal using an end of the year purchase. So hopefully we look a little sharper for those of you who are in Zoom, and going forward, hopefully we'll have more capacity to do bigger meetings.
Great. Questions from the commissioners? About the public? Any questions? Comments? Okay, thank you, Robert. Next, item number 3, media reports.
As this commission knows, this is a standing item on our agenda to allow the commission to have the opportunity to talk about media reports specific to the Ethics Commission itself, if that's happened in the past month, or more generally sort of dealing with ethics in Hawaii. 2 things I just flagged. There was a campaign legal center report. They do an annual report where they sort of look at ethics commissions across the country. The topic that they focused on this year was threats to the jurisdiction or powers of ethics commissions across the country, and Hawaii was identified, and specifically looking at the Office of Hawaiian Affairs litigation and what that might do to our jurisdiction moving forward. In addition, there was a report about a former state archaeologist and allegations of complaints involving that individual. We can't talk about that just because that is either an ongoing investigation or could be an ongoing investigation. And under statute, those are things that we are not allowed to talk about in a public forum.
Questions from the commissioners or comments? How about from the public? Okay, item number 4, COGO.
So commissioners, we just had the Council on Government Ethics and Laws, which is a international organization that we were both a founding member and a continuing member participating in. We just had our annual conference. This is a opportunity for us to share takeaways, things that we learned, things that we think are something for Hawaii to take a look at, or things that we can implement here. And I think I wanted to open this up for folks to offer their thoughts.
Thanks. You know what I'm gonna do? I'm gonna ask all the participants, what one takeaway did you get from this conference? I'll start with our vice chair, Commissioner Tobias. One takeaway.
One takeaway, it was a great conference, and I learned a lot about both the national and international things. And I guess my biggest surprise was the lack of teeth in many organizations. I thought it was well done. I like the panel atmosphere. That's more than one thing. But anyway, I think that what we have here in Hawaii is really great compared to many, many places in the nation. I was really surprised about the legislature because they seem to be able to point things out, but they don't really seem to be able to do a whole lot about them. And I find that really kind of, what's the word I want to use? It's just really awkward when you don't have teeth to pursue some of the things that you need to. Also learned quite a bit about some of the other organizations and some of the great work that some of the people that are in on the commission are doing. And I especially liked listening to some of the great speakers and to meet some of them and understand where they're coming from and what kinds of things they're doing in a business work community setting. So that was my big takeaway.
Commissioner Hall.
I was particularly impressed by the plenary sessions, and while I got a lot of the away from the workshops, I think it was interesting. As most of you probably know, COGO was founded in 1974, in response part to the Watergate affairs. And one of the plenary speakers was John Dean, and brought back the importance of careful vigilance for ethics. Mayor Karen Bass was there as well from Los Angeles, and she was very inspirational, looking at how community efforts can be used to, address the problems of the city, besides just enforcement. And, lastly, the craziest thing that happened that kind of tied things together is that there was a fire in Malibu. My sister-in-law and the brother-in-law lived in Malibu, and they had to be evacuated from that. But you had no sense of the fire downtown. It was, even though 4,000 acres burned, but it, put into perspective, one of the last plenary sessions by Professor Rick Hasson of UCLA Law School, where he addressed the issues of voting rights and how we are currently facing kind of the same firestorm in politics as Malibu was. Luckily, the Franklin fire was put out, with significant but minimal damage, and hopefully we will be able to survive in the same fashion.
Thank you. Let's go to Bonita. What was your takeaway? And then Jody.
I think all of the plenary sessions and the individual sessions that I attended were really well organized. They were plenary speakers, as Commissioner Hong indicated. They were really inspiring and thought-provoking. I attended several of the roundtable discussions for training, and some of the ones that were focused more on the smaller agencies and how they leverage limited resources and staff to do their work effectively. So that was interesting to hear. And I also attended some of the lobbying disclosures and registration panels, and focusing on who is the boss or the client. I think for my takeaways, some of the nuggets of ideas that I got, was to look at ways to streamline our information for the public via, whether it be our online complaint forms or requests for advice or guidance, and maybe looking at possibly developing public dashboards to summarize statistics or information that's publicly available, just to provide more information, that is accessible for the public, and summarizing the kind of work that we do. Some of the other areas that I thought about was looking at admin rules to clarify grassroots lobbying and who is the actual client. One of the ideas that I suggested to the organizers was perhaps looking at COGO Connects, which are the individual webinars throughout the year for 2025, and offering more workshops or demos for staff members from the different agencies. I think it's really hard to get information at conferences because it's so large. This is one of the largest COGO conferences with a large percentage of first timers. And I think for state and local agencies, they're looking for resources okay, what are ideas that we can do? And so I think COGO Connects offers that opportunity. And, I had offered, if they, to volunteer, hey, we can do demonstrations and share information how we do things, as well as exchanging ideas with other agencies of how they do things. And perhaps we can learn from them too at these COGO Connect workshop type of demos that may be available throughout the year.
Thank you. Jody.
I agree with a lot of the other speakers that it was very interesting. This was my first time at COGO, so I learned a lot about the international as well as the fellow states offices. One thing that I was kind of surprised by is that a lot of them are very small, less than 10 persons in an office. I think in one of the sessions, they were asking if by a show of hands, how many people were in your office, and a lot of them were less than 10. Most of the room was less than 10. So I think I agree that Hawaii is actually better staffed up and better funded than a lot of the other agencies. But the one that was, I guess, most significant for me was the discussion about penalties and fines. Some states, it was so low that the people that they're fining considered it just the cost of doing business. I think it was like when they were doing their filings, was $500 penalty if you don't file, and the company figured, well, if they're going to hire somebody, that's going to be more than $500, so they would just take the fine instead. So things like that were really interesting. I know we just raised our fines, but it makes a big difference, especially I guess for some of the big cities where you have big businesses, and they're going to be like, well, a $500 fine is nothing to them. So anyway, I felt pretty glad that I think Hawaii is ahead of the curve. So that was nice to find out. Thanks.
Thank you. Robert?
Thank you, Chair. I wrote down a whole page of specific ideas that we can actualize. I'm just going to mention one or two. One I really liked is some jurisdictions will post their guidance, anonymized version of the guidance. If they got a really interesting question that month, they'll actually post it without identifying who asked, with the idea that they can kind of share broadly, here is sort of the advice provided for this type of situation, which I think is a great idea and something, going to try to look at trying to implement for us. We currently have a post-employment restriction, so people leaving state service are limited in their capacity to lobby and or interact with their former agency for a 1-year cooling off period. One of the things I heard, which I thought was interesting, was a pre-employment restriction, specifically on matters which the employee worked on with a private employer. And that seems, I think in the past, attempts to do pre-employment restrictions have been met with, I think, reasonable concerns about limiting the number of employees that can join state service. But this seems like sort of a narrow restriction that seems pretty reasonable and on point. It may be too late to try to get it in the legislative hopper this year, but I think it's certainly something we should look at for next year.
Thank you. My takeaway, first of all, I want to thank our staff at our ethics commission, because it just showed me how above the curve we are in regards to what we're doing. I'll just give you an example. They asked for a war story. We figured out what the heck. And I mentioned about the Kana case without mentioning the name. And that's been going on for about 5+ years. And we'll take up from A to Z, and it's now in the Supreme Court. And we started on the hearing level and the Circuit Court, Intermediate Court of Appeals. And now we're going to go all the way up to the Supreme Court, and we're going to take them to task. And I got an applause, which really baffled me, which just showed the fact that we'll take everything that we got and we'll take it all the way, and how competent our staff is and our attorneys. So I want to thank our staff and attorneys, because listening, and I don't want to repeat, to some of these other offices, they're hurting. They're really hurting. I was also amazed that it's international, because we met about 9 individuals from South Africa. And I go, aren't you in the wrong conference? But they were here, and also Canada. All I can say is that, be thankful. I'm talking about to our commissioners, that we have such a competent and professional staff that can really guide us through doing our job. So I want to thank them. And the next COGL is in Atlanta, and hopefully it's not going to be as cold as the other venues. Last thing we did mention, why don't you come to Hawaii? And they looked at me and they said, they didn't say anything. But anyway, thank you everybody for your input. Anything else? Any questions from yes, Beth? Mr. Tobias.
Just one thing that I forgot to mention, it was the whole process of AI. And I was interested in it from the standpoint of what some of the ethics commissions are doing about it and what they did with it in the election, and some of the deep fake stuff and some of the cloning of voices and everything like that. And I think we haven't really looked at that, and I'm wondering if that's kind of a future thing that we might look at in terms of our own processes. You know, does that impact us?
It's an interesting question. If Chair, if you don't mind, just
Yeah, go ahead.
the legislature did consider a election AI bill last year. And I know the Campaign Spending Commission's been particularly on it, on that topic for, you know, voter, misleading voters potentially with, you know, fake AI messages. Commissioners, is there something specific that you can think of in the ethics or lobbying context that we should be thinking about?
If you do, why don't you contact Robert and discuss it with him? I don't want to do it now. Is that okay?
Yes.
Something that's pressing? Okay, any questions from the staff? How about our public? Any questions or comments? Okay, if not, thank you very much for everybody's input. Let's go on to the next item under 5, which is oversight, judicial branch.
So again, Commission, as you're aware, this is has been a standing item on our agenda. This is something the chair brought up in context of the U.S. Supreme Court ethics concerns with the conduct of the U.S. Supreme Court and examining Hawaii. As a result, I think our discussions with the judiciary, which have been very productive, they are proposing, one, to create a independent administrator that will act underneath the Commission on Judicial Conduct, who will be able to look at and analyze complaints that come in, and essentially will sort of be similar to our counterpart within the judiciary. In addition, they're proposing some really good rules that would require a much greater level of reporting of gifts, with a specific, you know, interest, at least in my part, on conferences and other things that judges might get invited to, and requiring that to be disclosed on a moving forward basis. I'd characterize this as a good step. And, you know, our intent is to draft with the chair and potentially for the chair's signature comments to be submitted by the end of the month. And so we'd be able to circulate those at our next, hopefully at our next meeting. But again, I think we're making good, meaningful progress. Recognizing also that we're probably going to get a new Chief Justice relatively soon. And, you know, hopefully we'll have the opportunity to continue this conversation, you know, going forward.
Thank you. And I want to thank commissioners for your input in regards to what was submitted by the judiciary. Any comments from the commissioners or any questions? How about the public? Any questions or comments? Okay, item number 6, proposed legislation.
Thank you, Chair. So attachment number 1 is just the legislative calendar for your information. Attachment number 2 is a proposal relating to administrative fees. In our interactions with the Campaign Spending Commission, they have a process by which they will issue a notice of order and fine, and the individual receiving it has the option of either 1, asking for a contested case hearing within 20 days, or 2, they can just go ahead and pay the fine. It's I would use the analogy of a parking fine system. It's kind of a simplistic way of handling some of these situations. And by comparison, our system, which requires the commission typically to approve a charge, search the charge, requiring the individual to answer the charge, and then a notice of hearing, is a much longer process. So the proposal here for fines under $1,000 is to add a new tool to our tool chest to try to resolve things faster and more efficiently, while leaving the individual with the same due process rights. And fundamentally, they can still ask for a contested case hearing. We envision, for example, if a lobbyist were to make a prohibited campaign contribution during the legislative session, you know, the facts will be relatively clear, straightforward. A check was given, received, and accepted within the legislative session. The type of situation where we could just issue a fine and hopefully have the matter resolved pretty quickly. So again, we're hoping this is something that will make things more efficient and faster. But we'd like your approval, obviously, before proposing this to the legislature to consider.
Questions from commissioners? The public?
Practically speaking, Robert, how many fines are less than $1,000 that we, deal with in this commission?
That's a bit of a tricky question because our administrative fines just went up. Previously, our max was $1,000, and so now we're at a $5,000. And so, it is sort of a new day. But we've issued a fair number of $200, $250, $500 kinds of fines in the past. And I think part of the process that we're looking at with the admin rules is actually creating a schedule, like almost like a fine schedule for certain activities. So that way, it won't be really something that a lot of discretion would be applied to. It'd be this is your first time abuse of X, therefore you get a $500 fine. And hopefully that just becomes sort of a standard operating process.
Just one note, in the conference, I thought we're above the curve, but in regards to fines, remember, we increased the fines from $1,000 to $5,000 per violation. Well, it seems like quite a few of the jurisdictions on the mainland already have 5,000. There was one jurisdiction, correct me if I'm wrong, had $10,000 per violation. We haven't got to that point yet, but I hope we don't need to. But it was very interesting. Anything else?
So unless there's no other questions, I'd ask if there be a motion to approve submitting attachment 2 or something in a substantive form to the legislature for consideration for introduction.
Just wondering if the title you want to put the word ethics in it for ethics commission fines.
Did everybody hear that?
Yes.
You want to say that again?
Just to include, ethics in the title of the bill.
Oh, okay.
To make it more descriptive.
Okay. Would that
narrow what you can do with the bill?
Okay. Would that suggest a change? I'll entertain a motion to approve.
So moved.
Moved by Commissioner Tobias.
Second.
Seconded by Commissioner Hong. Any discussion? Not roll call.
Starting with Vice Chair Tobias,
Aye.
Commissioner Thielen,
Aye.
Commissioner Becker,
Aye.
Commissioner Hong,
Aye.
Chair.
Chair votes aye, no objections, motion's carried. Thank you. Next.
I'm talking about attachment number 3, which is specific to lobbyist contributions. This is related to a law that passed previously. It specifically indicates that we have jurisdiction over lobbyists who make a prohibited contribution during legislative session. In addition, the Campaign Spending Commission has jurisdiction over contributors who make a illegal campaign contribution during the legislative session. There are fundamental fairness as well as constitutional issues with essentially fining individuals over the same actions from 2 different agencies. The intent of this bill is to make it clear who has jurisdiction over these types of problems. And we've been working with the Campaign Spending Commission. They are also meeting today, and they're going to consider essentially supporting a version of this bill moving forward. It is possible they may decide that they want to retain jurisdiction. So, essentially at this point, it's an agreement that these types of situations should be enforced, and it's just simply a matter of who enforces it. As proposed here, we would retain jurisdiction over state lobbyists, and they would refer that situation to us. They'd retain jurisdiction over the candidates, and we'd refer any situations we see of candidates accepting a prohibited solicitation to them and sort of work cooperatively with their office moving forward. The one issue that I should flag is that county lobbyists, lobbyists who only lobby at the county, are also prohibited from making campaign contributions to state candidates during the legislative session. And currently, there is no, that I'm aware of, ordinance at the county level prohibiting that behavior. So if that type of situation refer to a county ethics board or commission, they're really not going to do anything with it because, again, it's not prohibited at their level. So that's an issue we still have to kind of wrestle with.
Okay, so Robert, just in a question, is there a clear rationale why the campaign doesn't take ethical violations of the lobbyists, and would fall into our hands?
I'm not sure if I fully understand the question.
Why are we responsible for lobbyists and they're responsible for candidates? Why doesn't it just go to campaign spending commission?
Good question. So a two-part answer. I mean, we constitutionally have jurisdiction over lobbyists. It's a requirement, right? Mm-hmm. And we handle all the training. And so it's a mandatory ethics training or a lobbying training that all lobbyists have to go through. So we have a lot of points of contact. We have an advice mechanism. And so in some ways, our relationship or interactions with lobbyists is greater and a chance to sort of stay ahead of the curve with them. In addition, I think we're probably better resourced than the Campaign Spending Commission. The law prohibits even the promise of making a campaign contribution during the legislative session. Those types of investigations could, if there was a complaint of such a behavior, could require having to interview multiple witnesses and actually try to establish the facts of that situation. And I think we're probably in a better situation to handle that. And that's the main reason why we propose structuring it this way. Philosophically, I don't have a great concern with simply leaving it complete with the Campaign Spending Commission either. Just the main concern would be is I don't know if they have the resources to do that kind of investigation currently.
I guess it's a follow-up to Commissioner Hong asked. Is that a duplication of effort? What they're doing and what we're doing in the same issue?
Currently it is. I think the intent is to say whose Juliana is it going to be. And I think we have a great relationship with the Campaign Spending Commission. I don't think there's anything territorial. We're just trying to figure out what's the best mechanism moving forward.
I agree with you. We have a very good relationship with the campaign spending, but again, I hate to have a duplication of effort. If you think the staff thinks that we should just say, hey, it's your baby, go take it, rather than, it's less work for us.
I think the Campaign Spending Commission's debating this, and if they came out strongly feeling that way, then I think we would support that and maybe modify this bill and ask your permission to modify this bill to simply give it to the Campaign Spending Commission. Our proposal here is mainly just looking at the resources and sort of feeling that we may be better positioned to do the type of investigation necessary to enforce this law. They have 5 staff. They don't have the type of resources that we do.
Any comments or questions from the commissioners on this issue?
Just a little clarification, yes, Chair, if I could. Now, you talked about, was it the county not having the ability to do, I know they probably don't have the ability to investigate and do the things that we do, but if we send something to them, what happens to it at the county level?
As a practical matter, almost all county lobbyists are also state lobbyists. So as a practical matter, we're probably going to have jurisdiction in 95 or more % of the situation. I think it's going to be pretty rare to find a circumstance where it's exclusively only a county lobbyist making a campaign contribution. The challenge is counties constitutionally have jurisdiction over county lobbyists. And so we can't necessarily pass a state law or something restricting activity of county lobbyists, or at least it would be a constitutional issue. Currently, no county has a law prohibiting county lobbyists from making a campaign contribution during the state legislative session. And further, I'd even kind of argue as a policy matter, it's a little suspect. Why would they care? If it's only a county lobbyist, what do they care if they're making a campaign contribution to a state legislator? They're not trying to influence, presumably, if they're not state lobbyists, they're not trying to influence something at the state level. All that being said, it's an issue that still needs to be wrestled with. I can see 2 courses. The most likely one simply saying the Campaign Spending Commission will keep jurisdiction over contributors who are county lobbyists, and just leave it to the Campaign Spending Commission to enforce that.
Thank you.
Neat. Any other questions, commissioners? Any questions from the public? Okay.
Ask for a motion.
Okay. What motion do you want? You want to approve? Approve. Go ahead.
Move to approve in a substantive form,
Okay.
if somebody would be willing to make that motion.
Okay.
I'm approved.
Moved by Commissioner Hahn, do we approve? This, what is it? It's
Attachment 3 in a substantive form.
attachment number 3. Is there a second?
I'll second it.
Second. Commissioner Becker said a second, so thank you. Discussion? If not, roll call.
Starting with Vice Chair Tobias,
Aye.
Commissioner Thielen,
Aye.
Commissioner Becker,
Aye.
Commissioner Hall, Chair.
Chair votes aye, no objections, motion's carried, it's approved.
Thank you.
Thanks. That's it?
Yeah.
All right, oh my gosh. Item number 7.
No update, Chair.
Okay, moving right along. Item. I hope this is finished before my tenure is over, but anyway, item number 8. In regard to item number 8, I'm gonna ask you, I read this like 2 or 3 times. Can you explain what the issues are in regards to this? What happened in this case? I see it 2001. I'm a little lost. Yeah, who's it?
Crab and Pilates.
Okay.
Sorry, who are we? Who's talking?
If folks on the Zoom call can go mute if they aren't actively trying to say something. Item number 8 is the University of Hawaii Professional Assembly versus the Board of Regents of the University of Hawaii. Briefly, this was a ethics matter that was settled with an individual employee of the University of Hawaii. That University of Hawaii employee asked for legal representation from the UH General Counsel's office, which was declined. They submitted the matter to arbitration, and the arbiter found that we are akin to a court, and therefore legal representation should have been provided. And in addition, the settlement could have been proposed to the legislature for approval for payment, despite the fact that the ethics code is an individual responsibility, and historically it's never been interpreted. The general collective bargaining agreement's never been interpreted that way previously. We asked for approval previously from you to submit an amicus brief, which we have attached as attachment number 1, and I'm also providing to you amicus briefs filed by the Hawaii State Teachers Association, the Hawaii Government Employees Association. So this is a matter currently before the Supreme Court brought by UH, challenging this arbitration on general policy grounds. It is a difficult argument to make. Typically, courts want to defer to an arbitration. However, we felt it important as a policy matter just to point out that the ethics code is, again, an individual responsibility, and it's something that the individual is supposed to be following. They can't argue it's within their job scope to evade or to break the ethics code.
So the bottom line actually is the arbitrator in regards to whether or not to provide counsel for this teacher or professor basically ruled in his favor in both in representation, and what bothered me is that the word I was reading, and correct me if I'm wrong, but there was not enough training for him to understand that he couldn't do this. I mean, that kind of bothered me a little bit. But is that pretty much those are 2 issues? And really, the arbitrator did not side with us. And at the same time, the circuit court did not either.
Well, it wasn't necessarily us. This is the university, between the University of Hawaii and
correction, the university, yeah.
Yeah, again, if you want to talk about it in detail, I'd recommend considering going into executive session. Again, certainly talking about what's public in the file briefs. I think, the facts are stated there, so we can point to those.
Is there any of the commissioners like to discuss this more in detail? We can go and adjourn into executive session. I don't know if it's necessary. It was just more of a comment I had in regards to the case, and we shouldn't discuss the case. I just want to make sure that we understand the issues, that's all. Any commissioner? No, not necessary.
Okay.
Is that it?
We'll probably not include this as a standing item, unless, something else comes out of it, and then we'll add it back on the agenda and make sure we're sharing it publicly.
Okay. I mean, it was an interesting argument that we are not a court. We are a commission, although the arbitrator thought we were a court, but anyway. Keep us posted. Any questions or comments from the commissioners in regards to item number 8?
So what action do you need? Just approval of the amicus brief?
No approval necessary. Amicus brief is filed. This is more of a information sharing.
Did you hear Commissioner Hong's question? Okay. That's, I think, should do it. Any items? No?
No.
Okay, no further business. I'll entertain a motion to adjourn.
Move adjournment.
Moved by Commissioner Hong, seconded by Commissioner Thielen. We need a roll call. Yes, we do.
We can do it by voice.
Oh, okay. All those in favor of adjourning, say aye.
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 Thank you. Those opposed? Motion's carried. It is now 9:47. Let's take a 10-minute break.